How are you, sir?
I'm well, thank you.
Thank you. For how many years were you a state advocate?
I was a state advocate for approximately 6 years.
For 6 years.
Yes.
Now, and what then happened?
I had decided, after being in the Department of Justice since 1989 as a state prosecutor and being elevated to work in the Office of the Attorney General, I deemed at that stage that I had received sufficient High Court litigation experience, and I then decided at that point in time to leave the Department of Justice and to practice as counsel thereafter.
Now, for how long did you practice as counsel?
So, Chief Justice, I relocated from KwaZulu-Natal, came up to Gauteng, and I then became a member of the, as it was then known, the Independent Association of Advocates of South Africa, and I practiced since 1997, and I'm currently still an advocate.
Yeah.
Practiced actively until 2015, when I was invited to act in the Gauteng division.
Yes. I'm asking because at some stage you were the you were the, you say, employer, City of Johannesburg legal consultant. So I wasn't quite sure, and also lead instructor, practice management. I wasn't quite sure whether you were still practicing while at the same time having this employer. It was not clear what
Yes.
was happening. Did
The-
you take
the-
time off, or did you continue to practice while you were offering these services as
No,
well?
the position simply was that whilst I was practicing as counsel in Gauteng, I also had rendered services in my official capacity to the City of Johannesburg as a legal consultant.
So from 2015 up until now, were you acting continuously as a judge or from time to time?
CJ, I would say that from 2015, I have acted for 112 weeks in the Gauteng division, spaced between Johannesburg and Pretoria. And essentially, I have rendered my services over a lengthy period of time, with my practice literally taking a back burner at this moment in time.
Yeah. So you haven't been practicing since 2015?
I have intermittently dealt with one or two matters when I was obviously not acting, but essentially I had made the mindset that I was sitting as an acting judge in the Gauteng division, and I, in fact, to be honest with you, preferred this type of work as opposed to practice.
Yes. And from 2015 up until this year, for how many months have you acted, you would say?
I would say,
Or weeks, whatever the
yes,
case may
I
be.
have acted 112 weeks in the
One-
Gauteng division,
Yes.
which would equate to roughly about 28 months.
That's from 2015.
That is correct, Chief Justice. So 72 of those weeks have been in the criminal court, and 40 of those weeks have been in the civil court.
And during that period, how many times did you appear in court as an advocate? From 2015 until now.
Chief Justice, I think I may have appeared only once in an opposed motion matter.
Yes. Very well. JP?
Thank you, Chief Justice. Kasim, good afternoon.
Good afternoon, JP.
You've just told the CJ you've acted for 112 weeks and 72 of those have been in the criminal courts. Am I correct?
That is correct, JP.
That's where your strength lies,
That is correct.
right? But you've done other work as well, isn't it?
Yes.
You've done third court work, you've done urgent court work, and you've done opposed motion court work.
That is correct.
And how did you find that work, especially in the opposed motions?
JP, I found it very, very exhilarating and interesting in the opposed motion court. It's a fast-paced court. Just like the urgent court, you have extremely experienced counsel appearing before you, which obviously makes sure that you as an acting judge are on top of your game. And I think I'm actually thankful for the opportunity to have acted in these particular courts.
And you've rendered a total of some 177 judgments according to your list.
That is correct, JP.
But one thing I note in these judgments, the majority of them were handed within either a day or two of the matter being heard.
Yes.
How is that possible?
JP, the position very simply is, if I may refer you to my list of judgments handed down, you would observe that many of them have been written judgments. And in those instances where they were within a day, I would normally hand down extempore judgments.
Yes. So those that reflect a day, those are extempore judgments.
Yes, in most cases, they are extempore judgments if they're on the same day.
Yeah. Even in the opposed motion court.
Yes. If I may permitted to say, JP, in the opposed motion court, the acting judges generally get the files in advance. You normally would look at the files, take a prima facie view in respect of the matters that are before you. And once you listen to counsel, you obviously would know where you're heading to in the matter. And my view is that I do not want to unnecessarily waste time. If I have a proper view in the matter, I would normally hand down an extempore judgment.
Yeah. But not all the matters are that simple to be dealt with that way, unless your allocations were.
Well,
I'm talking about more experienced judges. They take time.
yes, no, that is very true. What I'd like to say, JP, is that many of the matters in the opposed motion matters, you have a very broad range of matters. So generally, some of the matters you can't put them into a box. They would take a longer period of time for you to apply your mind. But some of the matters are fairly straightforward, not very complicated. Counsel put together a good set of heads, and you are able to then, together with the heads, and correlate that with the argument that is raised, are able to take a prima facie view and hand down an extempore judgment.
Okay. Thank you, CJ.
Thank you. But I assume you are not like some of the judges I've worked with as a very junior judge, who would come with a judgment already prepared and typed to hear the matter. And once the matter argument is done, a person is reading judgment.
Yeah, no, CJ, that is one aspect of my practice as a member of the judiciary. I never, ever have written a judgment beforehand. I always err on the side of caution. I'd like to obviously listen to the parties, let them ventilate the matter properly to find out if it in fact accords with my prima facie view in the matter. And when I'm satisfied that the view that I would obviously hand down, and remember, CJ, you normally would always be handing down a judgment in the extempore judgment for the losing party. So you obviously would try to make sure that your judgment can stand scrutiny and is not going to unnecessarily be taken to a higher authority.
Yes. MEC?
I'm covered, thank you.
Thank you. Your excuse, Mr. Moosa?
Thank you, CJ. Thank you, honorable members of the committee.